Вітаю, колеги! Нещодавно в мене відбувся відеозв'язок з президентом Асоціації судових виконавців Вищого суду Англії паном Майклом Джексоном, який люб'язно відповів на мої запитання. Сьогодні я хочу надати вам можливість ознайомитись ще з одним виконавцем, судовим виконавцем Вищого суду Англії Мартином Лейшоном, який люб'язно відповість на мої цікаві і доречні на сьогоднішній день запитання. Тож, поїхали! Вітаю вас, Мартін! Розкажіть про себе, чому ви вирішили стати судовим виконавцем на території Англії та Уельсу?
That's a good one. That may require a lengthy answer. Okay, so my name is Martin Leyshon. I first entered the profession in 1989, so quite a lot of years ago. And from there, I undertook my training as formerly a sheriff, but now an authorized High Court enforcement officer. Since 1999, I've sat on the board of directors of the old Sheriff's Officers Association, which is now the High Court Enforcement Officers Association. I've served in a number of capacities whilst on the board, as vice chairman for 2 years and as chairman of the association for 6 years. I stood down as chairman in 2016, and last year I decided to take on the role of the complaints officer for the profession. As complaints officer, I'm dealing almost on a daily basis with other High Court enforcement officers and members of the general public, trying to reach a resolution on the complaint, whether that might be, looking at the complaint and judging the complaint and making a ruling on the complaint, and then suggesting that perhaps some form of compensation may be required to make the complainant happy if I find in favor of the complainant. If I don't find in favor of the complainant, then I will reject the complaint immediately.
А чи є у вас спеціальна комп'ютерна програма, система чи платформа, у якій працюють судові виконавці Англії та Уельсу? Якщо так, то чи це єдина система, чи їх декілька, чи є вона платформою для виконавців? Хто є адміністратором такої системи, держава чи все ж таки судові виконавці? І чи є перебої в роботі такої системи? Дякую.
But first of all, I'd like to explain a little about the appointment of an authorized High Court enforcement officer. So there are currently around about 48 appointed in England and Wales. So there's not many of us. So there's a very high standard to become an authorized officer of the High Court Queen's Bench Division. We are appointed by the Lord Chancellor or the Lord Chancellor's designated person who happens to be the senior master of the High Court. We are appointed in a self-employed capacity. We are regulated by the Ministry of Justice, and we are answerable to the judiciary. So that kind of explains the appointment in very brief detail. So the question is, do we have a special computer program, system or platform where English and Welsh High Court enforcement officers work? The way that the system is designed is that each officer is allowed to set up his own individual business. And as part of that individual business, he has the responsibility to have built and form his own computer system. So even though there are around about, shall we say, 5 or 6 main businesses offering or doing the bulk of the work in High Court, what you will find is that no one system looks like the other, because we have all had to employ software developers in-house to write the system in a specific language and to do specific things in order for us to carry out our activities in accordance with the regulation. So is it free? No, it costs a considerable amount of money. Some of the larger companies have invested over £1 million into their software system. So you can imagine it's also an ongoing cost because there's always development happening within the system. Client demands, client will ask, can I have this report? Can I have that report? And then the software writers will have to write up some internal language within their system in order to produce that report. The management of the system, again, is down to each individual office and the people that they employ. There is no regulation on the sort of system that we must have. That's all down to the individual business. Are there any issues from time to time? I think with any software system, there's always issues. You write one part of the software system and inadvertently it affects another part of the software system. And that's just an ongoing challenge, if you like, that each office will have. The services that our databases have access to in order to fulfill the High Court writs is that we will have pre-prepared forms for the court on our system. So when we get a judgment come in, that judgment and the information from the judgment is put onto a single individual database that produces all the court forms automatically so that it can be sent out to the courts. The more that you invest into your software system, the more likelihood that you will obtain better clients, better law firms, better debt recovery companies, because they look at the software systems and they say, well, what can you produce within your software system? What sort of reports can you give us on a weekly, monthly basis? So what we find is that the companies who've invested a considerable amount of time and effort and money into their software systems are the companies really producing and receiving the large bulk of the work.
До яких серверів та баз даних мають доступ судові виконавці Англії та Уельсу для виконання судових рішень? І чи доступ до таких даних здійснюється через паперові запити, інтернет-ресурси, чи безпосередньо через саму систему?
It's mainly through the internet, so we will have access to, for example, the driver, vehicle and licensing center. And then again, you have to go through a vetting procedure with the DVLA because they don't just give that license out to anybody. They need to know that you are a competent person, you are an authorized person, and that you have a court order when obtaining confidential information under the GDPR, the General Data Protection Rules, in relation to vehicles. In addition to that, we will have access to Companies House. So if we wanted to access a company that we're enforcing against, we can get information such as the latest accounts, the registered office address, the trading address, what do the financials look like, whether or not there is a company, like a holding company, are there any subsidiary companies? What does the shareholding look like? And that gives us a full picture of the company's financial state, where they trade from, who their accountants are, even before we go out to see them. Other areas that we can access would be land registry, to see if a property is registered in a debtor's name. That is a pay-as-you-go service, so there's a small fee, but all this can be accessed online.
Нашим глядачам буде цікаво почути відповідь на наступне запитання. А розкажіть про процедуру виявлення та списання коштів з рахунків боржника. Чи можливо через систему виявити рахунки боржника фізичної чи юридичної особи у банківських установах? Можете ви автоматично накласти арешт на такі рахунки? І чи доступна інформація вам про залишок коштів на рахунках боржника через саму систему? Дякую.
In England and Wales, which is a different enforcement procedure to our brothers up in Scotland, we cannot access a debtor's bank account. That is a procedure for a lawyer or a solicitor who would obtain a court order such as a garnishee order, but then they would have to know the debtor's account. They can't go on a fishing expedition and write to, 3, 4, 5 banks and say, oh, does debtor so-and-so have a bank account with you? They must know where the debtor banks. They must have the debtor's banking information. Then they have to apply to the court for a specific court order to go into the debtor's bank account and retrieve money by way of an attachment or what they used to call a garnishee order. So the simple answer is High Court enforcement officers are unable to access debtors' bank accounts, and it's a procedure that we do not get involved in.
А чи є у вас обмеження або заборони стосовно реалізації майна боржника? Наприклад, майно, яке не можна описувати та реалізовувати, мінімальний розмір суми боргу, за яку можливо звернути стягнення на нерухоме майно.
The minimum amount of debt that we are allowed to enforce for is £600. Anything under £600 falls outside our jurisdiction, and it's anything up towards millions and millions of pounds, even $1 billion if we had a writ in that size. There are certain restrictions on what you can take control of or what you can seize at the debtor's premises. So, for example, if it's a private house that we are attending, then we wouldn't be taking anything that belongs to children. They would be exempt. We have to leave debtors their basic needs and basic requirements for daily living. So if there's only one television in the house and they have children, we wouldn't take the television. If they've got 5 televisions, we might take 4 televisions to clear the debt. There are certain restrictions on bedding, for example, and we couldn't take bedding or we couldn't take beds. So there's all sorts of little restrictions that we have when enforcing a debt, and there's a whole list of these restrictions. I won't go through them now, but there are a list of restrictions that's contained in the Taking Control of Goods Regulations 2014, and all the enforcement agents who go on the road to enforce writs, they will be aware of what they can and cannot take during the enforcement procedure.
У нас є невелике додаткове запитання щодо будинку боржника. Якщо борг становить, наприклад, 50 тисяч фунтів стерлінгів і боржник не має нічого, крім даного будинку, але у нього є також діти, неповнолітні діти, ви можете проводити реалізацію цього будинку?
We are not allowed to take a debtor's house from them for a judgment debt, a money debt. But we do remove people who haven't paid, shall we say, their rent, and that is to do with an eviction order. So we would get a writ of possession, and then we can go in and we can remove the entire family from the premises, and that's the end of it for us. All we are doing then is handing back the property to the judgment creditor. But if we are enforcing a money judgment, so shall we say we go into the house to specifically collect £10,000, we cannot touch that house. That house is exempt. We would have to have a different court order, which is what we call a writ of possession. Then that enables us not to take the house as such, but to remove the family from the house and then hand the house over to the creditor or the bank or the building society. So it would be someone who has a vested interest in that house and hasn't been paid.
А розкажіть, будь ласка, нашим глядачам, як боржника повідомляють про початок виконавчого провадження? Чи надсилаються йому паперові копії повідомлень, постанов виконавця та інших матеріалів справи? Як боржник ознайомлюється з матеріалами виконавчого провадження і чи є у нього доступ до матеріалів справи онлайн?
Okay, that's a very good question. The answer is yes. We have to legally inform the debtor that we have an enforcement procedure against them. It's called a notice of enforcement. In that notice of enforcement, it will contain all the information that the debtor needs to know, such as who they owe the money to, when the judgment was made, when the judgment was transferred to the High Court for enforcement, the amount outstanding, any interest, any legal fees, the cost of the notice of enforcement, that will be in there. In addition to that, if they don't respond to the notice of enforcement, it will inform the debtor, these are the next stages, and this is what you will pay if you do not communicate with us. So if we have to make a physical attendance, the debt will increase substantially on the first visit. If we have to make a second attendance, it will increase substantially on the second visit. And if we have to remove goods to auction, it will increase substantially. But the debtor is informed every step of the way by this enforcement notice of what will happen with non-compliance. That's if they don't communicate with us. If they telephone us and say, I want to pay this off now, they have an opportunity to pay in full over the telephone with a credit card, and then they'll only get charged the notice of enforcement fee. If they're unable to pay in full, then we are compelled to go out and see them because this is the command that we have on the enforceable title. The command is to take control of the goods of the debtor. So we must attend. But the debtor's left in no doubt whatsoever what their obligations are and what the cost is for non-compliance. Some of the complaints that I get is that they've received no notice of enforcement. And the requirement is that it has to be sent paper form or electronic form, generally paper form, first class post at the last known address. So that would be the only requirement to give the debtor this notice of enforcement.
Яка дисциплінарна відповідальність передбачена до судових виконавців Англії та Уельсу?
Okay, that's a good one. Well, as I mentioned, we are regulated by the law, by the Ministry of Justice, and we're answerable to the judiciary. The final sanction within a disciplinary procedure is that the authorized officer could have their authorization removed. But to get that far, there has to be certain stages. So within our association, we have a complaints officer, which is myself. We have a complaints board, which is made up of 2 other board members and an independent legal person. And then we have an appeals board, which will be made up of the chairman, the president, and another legal person. So the complaints procedure is very transparent. Now, if we find in favor of the complainant, the complaints board can impose up to £15,000 a fine. They can also recover any legal costs that the board has incurred, and that's generally between £1,000 and £2,400. We can make an order for the authorized officer to pay compensation to the complainant, and that has a range. It depends on the gravity, if you like, of the complaint. We can also make an order for the enforcement officer to refund any enforcement fees that we feel they were not entitled to. And they have to pay a £500 administration charge plus a £200 initial administration charge for myself to handle the complaint. So the complaints procedure is written in what we call plain English. It's easily understood. And even the complainant, who's generally a member of the public, will understand what our complaints procedure is by simply reading it at the association's website.
Як приймаються рішення про застосування дисциплінарного стягнення до виконавця? Одноголосно, одноособово, більшістю голосів?
Any disciplinary sanction will be, if it's gone through the disciplinary process, will be made by the 3 officers who sit on the complaints board. So that would be the chairman, another board member, and an independent lawyer or solicitor. They will make that order, and it's really like an order of the judge. It's laid out as if it's an order from the judge. And yes, our members take it very, very seriously. They do not tend to take it in any other way, because it's all part of the transparent process that we try and enable the members of public to have. So there have been cases in the past where 1 or 2 members have lost their authorization. As a general rule, they would lose their authorization due to criminal activities, or perhaps retaining clients' money and spending clients' money and not handing that money over. So that would be a real breach of their authorization. Now, our association is unable, we cannot take their authorization away because it's not within our power. What we can do is make a recommendation to the Ministry of Justice and the judiciary that, shall we say, Mартин Лейшон needs to have his authorization removed, and these are the reasons why. If I then wanted to appeal that decision, I have chance of appeal, and I will be heard in a court of law, because it's people's livelihoods. So we don't take that other than very, very seriously. If we're going to recommend someone lose their authorization, then a lot of thought has gone into that, a lot of process has gone into it. We don't just make that decision on a whim or without any evidence.
Як часто ви отримуєте абсолютно безпідставні скарги?
I can give you those figures because I've only just prepared them for Thursday's annual general meeting. So from July the 29th up until today, I have received 100. Let me just check for you because this is quite relevant. Just get this one out. So I have received 124 complaints from members of the public, from solicitors, and so forth. I have rejected 61 of those complaints because they are groundless and without merit or foundation. I have resolved 9 of those complaints before it goes to the complaints board. I've passed 3 complaints to the complaints board where I've been unable to make a settlement between the 2 parties. One of the points of complaints procedure is that I will not handle a complaint until it has already gone through the internal complaints procedure of the enforcement company that they're complaining about. And I have 24 complaints that are awaiting that procedure. I have 9 complaints withdrawn, and I have 13 complaints pending. So you're really up to date on those figures, because I've only just prepared them today.
Нам дійсно дуже хотілося б дізнатися, як ви встигаєте робити свою роботу і водночас розглядати ці скарги, адже ми знаємо, що ваша професія дуже затратна по часу. І також, протягом якого періоду зазвичай розглядаються скарги?
Okay, that's a good one. Right. So first of all, how do I find the time? And the simple answer is I make the time. I make the time. Secondly, there's an automatic, when a complaint comes in by email, the complainant will get an automatic reply to say that the association has received your complaint. And we hope to reply to you within a 28-day period. So I have 28 days to start the initial correspondence. I have to say, I normally do it within 2 to 3 days, so I'm well within my time frame there. Some of the complaints are very detailed and, they might contain, 12, 13, 14 pages. And so I have to read the complaint, understand the complaint. And it's only when you have experience within the enforcement sector are you able to do this. It would be very difficult for our organization to bring some external person in and say, okay, well, there's the regulations, read those and you can deal with complaints. You have to have the practical experience to be a complaints officer, and you have to have the knowledge of the regulations, the code of practice, the national standards, and then I have to dissect, well, what is it people are actually complaining about? Because people just like to ramble when they're angry and they make a complaint, and they might go off on a tangent, but I still have to read it and analyze it and come to a conclusion, come to a decision.
В Україні у нас є схожа дисциплінарна комісія, яка складається з представників приватних виконавців, а також судді та 4 представників Міністерства юстиції. Чи ви вважаєте, що ставити представників Міністерства юстиції у комісію є хорошим рішенням?
I believe that ministers or the Ministry of Justice should stick to what they do, and that is to make law. I don't think it's the responsibility of the Ministry of Justice to be involved in the day-to-day activities of enforcement officers. In fact, how could they? Where would they get the time from? So there has to be a certain amount of self-regulation within each office. As long as each office has the regulations to follow, and if they are following it, it shouldn't be a problem. It becomes a problem when officers go off and do their own thing, and they work outside the parameters of the law. And that's where our association comes in, is that we are regulating our members. We are there to ensure that they follow the procedures of the regulations laid down by the Ministry of Justice. We're there to ensure that they follow all best practice and the national standards. And that really is our only parameter. And I can tell you that's enough. We do not go in and check on members' offices, on how they're doing. We will only deal with a member when we have a complaint. And if we get so many complaints about the same thing, about a member, then we know that we may have a little problem there, and we can address that problem. Maybe it's a case of they need further training, or they need some direction and more guidance from the association. So we're not there to beat them with a sledgehammer. We're there to ensure that they are complying with the rule of law, because justice has to be attainable for everyone.
Особи, які працюють в комісії з питань скарг, як довго вони займають зазначені посади?
The board is made up of 11 members, and at each annual general meeting, 4 members have to step down, but they can be re-elected by the entire membership. So it's on a secret ballot paper. So for example, I've been sitting on the board since 1999, and every 2 years I have to step down, but then I keep getting re-elected. So once you're re-elected onto the board, It is then the board that decides the officers' roles. So we will have a chairman, a vice chairman, a treasurer, a complaints officer, a complaints board chairman, and it will be the board that actually decides, focusing in on the skill set of the individual officer. What's the old saying? You can't put a round peg in a square hole. You have to put a round peg in a round hole. So it's pointless in putting a board member into a role and you just know that he's not going to be any good at it. So you pick the best of what you have. So yes, I mean, anyone could not be voted on at the annual general meeting, but it's very rare because we do it in a voluntary position, in a voluntary way, and I think the membership appreciate that.
Як нам відомо, Англія та Уельс відійшли від принципу територіальності виконання судових рішень. Назвіть основні причини, чому потрібно відійти від принципу територіальності у сфері примусового виконання судових рішень.
I can speak on this with great experience. Why? Because I was part of the old system and I've been part of the new system. So the old system had 52, what we call 52 different territorial regions, i.e. they were called shrievalties. And there was an officer appointed into each shrievalty, and that officer would get all the work in his region. He didn't have to fight for it. He didn't have to go out to get it. All he needed was the appointment, and the work would come into his workflow. So I was in a position before 2004 where I was in charge of several regions. And my clients, as indeed many of the officers' clients were saying, particularly lawyers, why do we have to send our enforceable title to Officer A because he's absolutely rubbish? He's not invested in anything. He's got no computer system. It's all handwritten. You can never get him on the telephone. This is ridiculous. So there were huge complaints coming from the Civil Court Users Association on why were they marooned to using inefficient, inadequate sheriff officers who just sat back in their chair, smoked their cigars and waited for all the work to come in, and basically stuck two fingers up to the judgment creditor. So things had to change. And they brought in the 2003 Courts Act, which enabled all sheriff officers to get reappointed as authorized officers. And then we had to apply with a business plan. How can we cover the whole of England and Wales? So we had to produce a business plan. This is what we're going to do. This is what we're going to invest. Since the reforms, the level of service has gone through the roof. Clients have come to High Court enforcement that would never have dreamed of coming to High Court enforcement prior to 2004. I would say that we have quadrupled our workflow by having healthy competition against the enforceable companies. And that competition has created standards that were down here, but now they've gone up there. So for any country, and I'm also an expert for the Union Internationale Justice de Justice, and I would say to any country that is looking at territorial enforcement, forget the regions, make it global. You will never look back, and the best will survive. The officers who sit back in their chairs and do very little and get paid very well for it They are the ones that won't survive. You have to give customer choice. I'm a court user. I issue, shall we say, 1,000 cases a year. I want to decide who goes out and enforces that 1,000. Not you, Mr. Ministry of Justice, telling me I have to send it to this one, I have to send it to that one. Why should I? I want him. He's the best. He's got the best procedures. He's got the best enforcement officers. He's got the best computer system. I want to use him. Thank you very much.
На сьогодні в Україні питання територіальності є досить актуальним. І все ж таки, чому Україні слід позбавитися принципу територіальності?
I can tell you why. Because clients demand it. It's very simple. Civil court users demand it. If you want to raise standards in the industry, take away the regions. Because you'll never raise standards otherwise. And, you know, were there people within our industry that were affected by this? Yeah, they were. And it's just too bad. If they couldn't produce, then they didn't receive any business. That's their problem.
Переконаний, що нашим глядачам буде цікаво почути відповідь на наступне запитання. А як все ж таки відбувається пошук клієнтів?
Okay, well, how do we search for new clients? That's very simple. Good marketing material. We have business development managers, relationship managers. Getting court users on board is all about relationships. You build a relationship with the client, you look after the client, and you retain the client. So regular communication, regular reports, regular this, regular that. And when we go to see a new client, we say, well, look, we can give you this in terms of service and delivery. Give us a try. What have you got to lose? If you like what we do, then give us more work. But I can guarantee you, if I can't get your money in, nobody will.
В мене є додаткове ще запитання. Якщо виконавець Вищого суду втрачає уповноваження на роботу або, не дай Бог, помирає, що відбувається з його справами? Хто отримує ці справи? Вони передаються у примусовому порядку, чи виконавець має право від них відмовитися? Дякую.
Issued in personal names, right? So I get writs issued in my name, and therefore I have a personal responsibility and a liability in law for the conduct of that enforcement procedure. Every year we produce a form to our association, and on that form I have to nominate a second in command. So if something happens to me, my nomination is already there, that this person will be allowed to enforce the writs in my name even if I died.
Переконаний, що відповіді, які ви сьогодні почули на мої запитання від пана Мартіна, були для вас цікавими та корисними. Я впевнений, що приватні виконавці в Україні повинні застосовувати той досвід, який вже десятиліттями застосовується судовими виконавцями Вищого суду Англії та Уельсу. Тож, дякую за увагу і до нових зустрічей!